Hello and welcome to the Living Trust webinar, Inheritance Planning for You and Your Family. I'm attorney Bob Bergman, and I'm so glad you're joining us today. You're going to learn a ton, and this is going to be a great use of your time. It's very important that you do not try to take any of the information that I present in this webinar and try to apply it on your own. Estate planning is a specialty in law practice, and there are many mistakes that can be made without the guidance of an experienced counselor. This presentation is focused on those who are unmarried, widowed, or divorced, or who are married but wish to plan for their separate property in the marriage. Many issues are the same. The best way to get the most out of your time on this webinar today is to turn off your phone, close your door, close out Facebook. You'll get way more out of this if you get rid of all those distractions. You really do deserve this time for yourself and ultimately for your family. Before we get started, let me make some promises to you. Time will go by quickly, you will learn a lot, and you will be entertained. A little bit about me. I've been a resident of Santa Clara County since 1968. I went to local colleges, including De Anza College and San Jose State University, and I have my Juris Doctor law degree from Santa Clara Law School. I'm also a board-certified specialist in estate planning, trust, and probate law, as certified by the State Bar of California Board of Legal Specialization. For the next hour or so, I want to share with you all the secrets of estate planning. There are a lot of misconceptions out there, so my goal with this webinar is to leave you with a better understanding of what can go wrong without estate planning and what legal documents you need and how to get them in place, so you can make educated, informed decisions about what is best for you and your family. Let's start with a good working definition of just what estate planning is. I want to control my property while I'm alive, take care of me and my loved ones if I become disabled, and give what I have to whom I want, the way I want, and when I want. Furthermore, if I can, I want to save every last tax dollar, professional fee, and court costs legally possible. I find that most of my clients have this in mind when they come to see me, and this is what they mean by estate planning. So what is your estate? Well, it's the things that you own, which I call your stuff, and your family. The things that you own include things like retirement plans, your residence, perhaps residential or commercial income properties, cash in the bank, stocks, bonds, mutual funds, automobiles, antiques. It also includes life insurance policies, which are an asset that's often missed because it doesn't pay out until somebody has died. Your estate also includes your family, such as your spouse or partner, children and grandchildren, parents, siblings, or anybody else you consider to be your family. For those who have minor children or grandchildren, defined as children under the age of 18 years here in California, there's an important question that needs to be answered, a question that I hope every parent has asked themselves at least once. If I go out tonight and don't come home, what would happen to my children? The reality is that without proper planning, your children or grandchildren could end up in the broken, underfunded foster care system for a few hours, days, or even weeks. They could end up with relatives you would want to raise them, or maybe with relatives you would not want to raise them. Or, with proper planning, they could end up with close family friends instead of your own family, if that is your wish. So the rule is if you haven't nominated guardians in a will or separate nomination of guardians, and you and your partner or spouse pass away, a judge will choose for you. In other words, a complete stranger will decide who gets permanent custody of your children without any input from you because you didn't get your wishes down in writing. They'll have no choice but to try to figure out who you would have wanted on their own. They'll do the best they can with the information they have, but they don't know you or your family, they don't know your preferences, and they don't know what you would have wanted. To deal with this issue, I've developed the Children's Legacy Plan. This is a series of legal documents designed to deal with the short-term and long-term needs of minor children. It includes the designation of temporary caretakers, which identifies one or more people that you've authorized to care for your children until a court can appoint a permanent guardian. It also has a nomination of guardians that identifies who you wish to take care of and raise your children. There's also a confidential exclusion of guardians used to identify those persons in your family that you would not wish to be guardians for your children. This document can be presented to the court if necessary to give the court information they wouldn't otherwise have. Then a medical power of attorney for minor children identifies people that you've named to make medical and healthcare decisions for your children if you're unavailable for some reason. There's a lot of reasons to do estate planning. For example, we just talked about naming guardians for your minor children. Or you may be concerned about your family fighting with each other after you're gone, and you want to make sure that you've put things in place in writing to prevent that as much as possible. You may be facing emergency planning because you have a terminal diagnosis of a health condition, or you have an upcoming risky medical procedure that you're facing and you have no plan in place. You may have a special needs child or other relative that you're caring for that will need their inheritance properly managed so that it's not subject to spend down requirements by the government. You yourself may be facing a nursing home stay, and you want to make sure that your estate plan can provide for the ability to do planning for Medi-Cal in the future without having to go into the court system. You may also have debts or taxes that could force the sale of the family home or family business to pay off those debts or taxes that were owing at your death. Most families will look at some of the following reasons to actually do estate planning. Avoid conservatorship and probate, eliminate or minimize legal fees, eliminate or minimize federal estate taxes, preserve income tax benefits, preserve low real property appraised values if allowed, protect your family's inheritance, pass on your values to your family, and above all, have peace of mind knowing that there's a written plan in place for the family to follow. Families come from many different backgrounds with different ethnicities, religions, cultures, and financial situations. Because of this, one-size-fits-all planning is not appropriate for a family because every family situation is different. To help with our discussion on estate planning today, I'd like to introduce Anna Walker, who became a widow 5 years ago when her husband Joseph died. Anna has 2 adult children, her daughter Karen, who's recently divorced, with a young son Jimmy, and her son Paul, who's an engineer at a tech company in Palo Alto. Anna wanted to know what her estate planning options were. After discussing her situation, including that she had a home to protect and pass on to Karen and Paul, we determined that the best and most flexible planning option for Anna was to use a revocable living trust. The revocable living trust consists of 3 parts. It's revocable, which means you can change your mind. Whatever decisions you make today can be modified, amended, or completely changed in the future. It's created while you're alive and not after your death, and it's property held by one person for the benefit of another person. I explained to Anna that the revocable living trust is like a wooden toy box for her toys being her home, her bank accounts, brokerage accounts, and personal possessions. In the case of Anna, she creates her living trust toy box as the trustor, also called the settlor, grantor, or trust maker. As the trustor, she's also the owner of all the toys in the toy box. Next, Mary and Ed create an instruction manual for their toy box called the Ramirez Living Trust Agreement. Anna then signs the Anna Walker Living Trust Agreement as the trustor and the trustee, i.e., the person in charge of the toys in the toy box. Anna then transfers ownership of most of her toys from herself to herself as trustee of the Anna Walker Living Trust. Certain assets are not transferred to the ownership of the trust, including Anna's retirement plans and perhaps stock options and restricted stock units. The trust agreement tells the trustee how to use the toys to take care of Anna as the primary beneficiary of the Anna Walker Living Trust. There may also be instructions to take care of other beneficiaries as well, such as minor children, grandchildren, and other relatives. For very large estates, the revocable living trust may be able to deal with the federal estate tax, also known as the death tax. There are some exclusions from the death tax when somebody dies. The first is the unlimited marital deduction. An unlimited amount of property can be directly transferred to a surviving U.S. citizen spouse without death tax, or to a special type of trust called a Q-tip trust, which is outside the scope of this webinar. These transfers have the effect of deferring any possible death tax on the property until the death of the surviving citizen spouse. If unmarried, only the applicable exclusion amount will apply to someone's estate when they die. As can be seen, the current applicable exclusion amount has increased dramatically over the years and is now $13,610,000 here in 2024. There's a 40% tax on estates over that size. It should be obvious that most families will not be affected by the death tax because most family wealth is well under the multi-million-dollar exclusion that would be available to an individual or to each spouse in a marriage. The more important tax planning in California today is income tax planning and real property tax planning. There's a type of property that can be owned that's called a capital asset. Capital assets include things such as your personal residence, stocks, bonds, mutual funds, investment properties, precious metals, gems and jewelry, and coin or stamp collections. Capital assets receive special tax treatment when they're bought or sold and a profit or loss is realized from the sale. These are called capital gains or capital losses. Proper estate planning can assure that there is a step up in cost basis at the death of an individual owner. This type of tax planning is governed by the Proposition 19 law, which took effect in February of 2021. All of the details of that law and its effect on real property exclusion from reassessment is beyond the scope of this webinar. The well-drafted Anna Walker Living Trust can also provide for a trust protector to assure that Anna's wishes and desires may be carried out in the future after she's gone, especially if there are changes in the law or in family circumstances. The Revocable Living Trust can also provide for asset protection for a surviving spouse or life partner if she had one, and ultimately for her children Karen and Paul as well. This was done by Anna deciding to leave her property in special asset protected trusts instead of leaving the property outright. Leaving property outright to a spouse, partner, children, or other heirs may result in the inheritance being lost. For example, beneficiaries that are too young or are financially immature can easily lose an inheritance with poor spending habits and the lack of knowledge about proper investment. Beneficiaries with drug, alcohol, gambling, or other addictions are also at risk of losing inheritance because of indulging in the addiction. A disabled or special needs beneficiary may find that the benefits that they're receiving from the government for their disability may be cut off or lost entirely if inheritances are received outright. Most government programs are needs-based, and receiving an inheritance outright may trigger a claim for reimbursement from the government for benefits already received. It may also cause the loss of future benefits until the inheritance has been almost completely spent. Because of the tendency for people inheriting to mix their inheritance into their current marriage, there's always the risk that the death of the beneficiary will lead to the entire inheritance passing to the surviving spouse of the beneficiary, or, in the event of a divorce, half or more of the inheritance passing to the divorcing spouse. This is instead of having everything go back to the family where the inheritance came from. Finally, a beneficiary who has creditor problems, owes taxes, or is in bankruptcy may find their inheritance taken from them to satisfy the bills and taxes. Is there an alternative to lost inheritances? Yes, the Castle Trust Planning Option. The Castle Trust Planning Option, more generally known as Legacy Trust or Dynasty Trust, is a planning option that involves leaving property in a trust for the benefit of a surviving spouse, partner, children, or other beneficiaries instead of leaving it to them outright. The inheritance is in a treasure chamber inside a castle with thick walls, a drawbridge and a moat, and a heavily armed defender who is the trustee. The trustee is both in charge of distribution of the inheritance and charged with defending against those who would take the inheritance away from the beneficiary. The trust that is created is a lifetime trust, and the inheritance inside is distributed to or for the benefit of the beneficiary of the trust for that beneficiary's lifetime needs. The distributions are generally limited to distributions for needs in the areas of health, education, maintenance, and support, which is often abbreviated as HEMS. Maintenance and support includes things such as food, clothing, shelter, recreation, and vacation. For maximum asset protection, distributions may be solely in the discretion of the trustee, with no requirement of all that distributions be made at any time. Castle Trust Planning provides all the use and benefit of an inheritance without the problems of an inheritance that can be created by direct ownership. An independent trustee can make distributions to a beneficiary for any purpose, even exceeding HEMS. This planning can protect the inheritance from creditors' claims, spousal claims in a divorce, loss of government benefits or reimbursement claims for government benefits already received, and personal bankruptcy of the beneficiary. In the case where the beneficiary has existing problems that are known, you can provide that an outside trustee handles all the property for the benefit of the beneficiary. This would be the case if the beneficiary has a drug, alcohol, gambling, or other abuse problem, is financially immature, in a bad marriage, and several other situations. Additionally, with planning, the inheritance can be passed on to the next generation after the original beneficiaries, free from the federal estate tax and free from another tax known as the generation skipping transfer tax. Another useful tool is a power of appointment, which can permit your beneficiary to direct where the inheritance will go when the beneficiary dies. This could be very useful if you have beneficiaries born after you've died who may have special needs or other considerations. At this point, you might be asking whether or not using the revocable living trust is really necessary. What about other planning options, like doing nothing at all or making a will, using joint tenancy ownership, or using beneficiary designations on accounts? First of all, let's talk about the most popular planning option in the country today. In fact, about 2/3 of Americans choose this as their estate planning option of choice. Do nothing at all. There's some advantages to doing nothing at all. There's no out-of-pocket costs. You don't have to deal with lawyers or paperwork. You don't have to think about dying. And for some people, their attitude is, hey, I'll be gone, so why worry about it? The decision to do nothing at all is called dying intestate. This means that you have no last will and testament, and the state of California has written a plan for you. It's called the laws of intestate succession, which is a fancy legal way of saying who gets your stuff when you die if you don't have a plan. When you die as a resident of California, if you have property in your name or payable to your estate greater than $184,500 in value, or if all you have is real estate worth more than $61,500 fair market value, your estate will go to the probate court in your county of residence, where the probate judge will decide who gets your property based on the laws of intestate succession. A less common but still common planning option is to make a will or last will and testament. Contrary to popular belief, a will does not avoid the probate process. In fact, Having a will means that you want your estate to go through the probate process. This is called dying testate, which means you have a last will and testament. Now, similar to dying intestate with no plan, if you have property in your name or payable to your estate greater than that $184,500 in value, or real estate worth more than $61,500 fair market value, your estate will go to the probate court of the state of California. The probate judge will follow your wishes as expressed in your last will and testament. The probate process when you have a will is the same as having no estate plan at all. What happens in probate? You can see a short list of what happens in probate on this slide. Understand the true purpose of probate is to make sure that your taxes and other bills get paid from your estate, including the IRS, the Franchise Tax Board, and your other creditors. And at the end of the process, anything that's left is distributed to your heirs under the law. There are costs associated with probate, some of which are tied into the gross fair market value of your estate. For example, this $1 million estate may represent a home in Santa Clara County that has a $1 million loan on it because of a decline in the housing market. Even though there's no equity in the property, there are fees and costs assessed by the probate law and the probate court, some of which you see on the screen here. As can be seen, there can be nearly 5% of the gross value of the estate in fees and costs, even if there's no equity in the property. Everything becomes public record in the probate process. Everything you own, everybody you owe, who your heirs are, including their names, ages, the property they're receiving from your estate, and where they live. It can take 1 to 2 years or more before distribution of property to your heirs. And the probate court actually puts a limit on how much property can be released ahead of time. That's called the family allowance. It may well be that there's no money available for tuition for your children's school or money for them to buy a home or start a business. This is because the property's all tied up in the probate court until the judge orders it distributed at the very end of the process. Additionally, if you happen to own real estate in states other than California, it's possible there will need to be additional or ancillary probates in those other states. It's not unusual for a family to walk away from something like a deeded timeshare, such as those shown here in Hawaii and Florida, because the cost of probate may actually exceed the value of the timeshare itself. So having a revocable living trust avoids the cost, time delays, and public nature of the probate process. Now let's say you suffer a stroke and end up unable to handle your finances. Your spouse goes to your bank or Charles Schwab to try to get some money out of your IRA to pay some medical bills, but your spouse is told there's no authority to get money out of your IRA. This was in spite of the fact that you had a will naming your spouse as your personal representative. You see, while you're still alive, your will has no effect. In fact, it's not effective at all until you die. Because of this, your spouse may have to go to probate court to get a conservatorship for you. A conservatorship is a guardianship for an adult. It's sometimes called a living probate because many of the steps that take place in the probate process also take place when somebody goes through the conservatorship process. The probate court will appoint your spouse as your conservator to take care of you as the conservatee, and you're said to be conserved. Conservatorship has its own set of fees and costs associated with it, including court investigators' fees, attorneys' fees, and ongoing accounting fees for as long as you're conserved. You can avoid conservatorship by having other legal documents in place besides just having a will. First of all, the general durable power of attorney. This grants authority in advance to someone to handle your financial affairs. Now, there's a form that the state of California has created called the statutory form power of attorney. Unfortunately, the statutory form is inadequate because there are many types of powers and authority that you might want to grant to someone that are not actually contained in the form itself. Unless you have access to a copy of the probate code and know what you're looking for, you'll not realize what those powers are that are missing. Some of these special powers could include the following: authority to make gifts, authority to do more estate planning, authority to do long-term care planning. The next document is the Advanced Healthcare Directive, which grants power and authority to someone that you've named as your healthcare agent to make medical and healthcare decisions for you. Again, the legislature has created a document called the Statutory Form Advance Directive, which is available at the business office of any major hospital. The unfortunate problem with the statutory form is that it does not give much of any guidance to your healthcare agents, and it certainly gives little or no guidance to your doctors. You see, the reason for the advance directive is not only to give somebody authority to speak for you, but also to give directions to your doctors if you run out of healthcare agents. The last document is the HIPAA authorization form. HIPAA, or the Health Insurance Portability and Accountability Act, is a federal law dealing with medical privacy. You may not realize it, but even if you're married, legally your spouse cannot get any medical information about you from your doctor or any other healthcare provider without your express written consent. The HIPAA authorization tells the healthcare providers to whom they're actually authorized to release medical information. Having a revocable living trust and the previous 3 legal documents avoids the cost and public nature of the conservatorship process. A will does not affect certain types of property that you may own, such as beneficiary assets or joint tenancy assets, both of which are discussed later on in this presentation. But there's another problem. The popular self-help planning option called joint tenancy ownership or joint tenants with right of survivorship. Joint tenancy property is part of your death tax estate, which means that it's subject to federal estate tax, discussed later in this presentation. Joint tenancy property is not subject to probate proceedings, and it's not controlled by any will or trust you may have prepared.
There are significant problems with joint tenancy ownership. Anna decided to add her 2 children, Karen and Paul, as joint tenants with her on everything she owned, her house, her bank accounts, and her brokerage accounts. Anna reasoned that if joint tenancy meant that her children didn't have to go through the probate process, then that outweighs everything else. Unfortunately, there were a number of bad assumptions and potential problems with Anna's approach. Anna did not realize that her son Paul's tax problems with the IRS could lead to her home being sold for his share of the property, or that her bank accounts could be levied against as well. This is because Paul was an owner of an interest in Anna's home and bank accounts, which made his interest subject to his creditor's claims. She also didn't realize that her ability to obtain a HELOC, home equity line of credit, or other loan, or a reverse mortgage to provide more income in her later years was significantly impaired. This is because, as co-owners of the house, Anna would need Karen and Paul to agree to and sign off on any loan on the property. If one or both of her children were living with her or moved in after the transfer was made, Anna could not even make them move out if there are problems. This is because they are now owners of the house, and ownership carries the right to occupy the property. Additionally, by putting her children on the title of her home as joint tenants, Anna made a gift of her cost basis in the property. If the property goes up substantially in value over the years and then Anna dies, her children may end up paying capital gains tax on their shares in the property when it's sold, because only Anna's 1/3 interest will receive the step up in cost basis at her death.
Having a revocable living trust avoids the inherent problems with joint tenancy ownership. Another self-help planning option is the use of beneficiary designations on various types of assets. These include assets such as 401k and 403b plans, IRAs, pay on death or transfer on death accounts, annuities, and similar property. Beneficiary designations have their own set of potential problems. When you use a beneficiary designation, you're giving up control over the distribution and use of the property in the future. Most people would think it's a bad idea to leave a large sum of money outright to an 18-year-old, but that can easily happen if the only planning being used is a beneficiary designation that includes minor children. Your wishes in a will don't affect assets with beneficiary designations, like life insurance or accounts with pay on death designations. Having a revocable living trust avoids the inherent problems with using beneficiary designations.
The revocable living trust recommended for Anna will avoid all the problems that could result from dying intestate with no planning, just making a will, using joint tenancy ownership, or using beneficiary designations. That's why it's highly recommended as the best estate planning option for many families.
There are many self-help planning options available for those who do not wish to use the services of an attorney. These include online websites like LegalZoom and Susie Orman, and self-help books that can be picked up in a bookstore. The self-help planning options share a lot in common. They tend to be one size fits all with little or no customization. They're often relatively inexpensive, but they have little substance to them, missing important provisions and not dealing with issues that may be very important. Finally, and most disturbing, none of these self-help options take any legal responsibility if the living trust planning does not work for your family. Unfortunately, that's often discovered after you've become incapacitated or died, forcing your family to go to court to try to fix the problems. In some cases, the problems cannot be fixed, and the result is a distribution plan that may be something completely different from what was intended. Another planning option are trust mills who offer lots of seminars. Now, trust mills tend to not be companies or attorneys that are local at all. They often offer lots of seminars in an area at the same time, and they offer extremely low prices. They're just interested in getting your financial information so they can upsell you with financial products that make them lots of money. Another planning option is to use an attorney that does wills and trusts. Any attorney can represent themselves as an estate planning lawyer. Passing the bar examination in California is the only legal qualification. Unfortunately, many general practice attorneys sell wills and trusts while they engage in several other areas of law. Most of these attorneys may have attended a few seminars or webinars on living trusts. They probably use forms from a book and will likely use the statutory forms of power of attorney and advanced healthcare directive. As I've already indicated earlier, these are often inadequate. The general practitioner attorney often has a short interview process and uses an assembly line approach for the preparation of living trusts, selling living trusts like they were tires or a box of cereal. Because of a lack of both knowledge and real expertise, important issues are often missed by the general practitioner, which may have the same disastrous consequences as the self-help planning options I described before. Also, the general practitioner frequently cannot explain many of the provisions in the trust document prepared for a client. A better idea is to work with a specialist estate planning lawyer such as me. Here's what I want you to remember. When you work with a certified specialist in estate planning, trust, and probate law, you are paying for the guidance and counseling about how the documents should be drafted, not the documents themselves. If you've worked with a lawyer before, you're probably somewhat familiar with hourly billing. This means the attorney keeps track of how much time they spend on your matter in 6-minute increments. This can be really stressful because you never really have any idea how much it's going to cost you. Also, the traditional practice of law tends to be very reactive. Problem falls in your lap, you're reacting to that problem, trying to put out an expensive fire. And ultimately, you could end up being a number. Your matter starts, your matter ends, and you don't have any ongoing guidance on how to avoid problems in the future. Now, I flip the traditional experience on its head. Everything I do is a fixed fee, agreed to in advance. You don't have to worry about being charged for every little call and email because I don't keep track of my time. You may have a million questions about your plan, And I promise you, I've had clients who do. It's all part of your fixed fee. Also, I love creating estate plans for my clients because it's very proactive. We're not responding to negative situations. It's all about making sure your family won't have to deal with an expensive mess when you're gone. And I really do value relationships with my clients. I want to stay in touch with you over time because I know that your estate plan is not really something you do once and then you never think about again. Your life is going to change and laws may change as well. I want your plan to keep up with those changes. Okay, let's talk about my estate planning packages and fees. Bargains are good when you're shopping for paper towels, but going cheap on a parachute, a surgeon, or fire extinguisher could have devastating consequences. Estate planning is like anything else. You get what you pay for, and it's worth it to make the investment to get it done right. Frankly, not planning will cost you much more than working with me. Planning can save your family thousands or even tens of thousands of dollars in lost time and privacy, and it could save your children from losing their inheritance. I offer 3 levels of living trust planning. I have found that most clients fall into one of these 3 levels of planning, so you can decide which level of protection meets your family's needs.
The basic trust plan is for a modest estate with no complications, where you simply wish to transfer property to a spouse or other heirs. It has no tax planning of any kind, no asset protection planning for the inheritance by a spouse, children, or other heirs. There's little or no customization permitted. The Advanced Healthcare Directive is not custom drafted, and this can't be used if you wish to have special needs planning for a child or other relative incorporated into the plan, or if we need to do planning for a non-citizen spouse. The enhanced trust plan is appropriate for a moderate to large estate that would be subject to probate, which would be an owner of real estate, or if no real estate is owned, an estate that exceeds $184,500 in value. This can be appropriate for an individual who is married with substantial separate property assets, a non-citizen spouse, beneficiaries, or proposed trustees. This type of plan is only intended to pass property from one generation to the next with no additional planning.
Then there is the addition of the Castle Trust planning. This provides asset protection for your children or other heirs. And it's especially designed to deal with the problems of the underage or financially immature beneficiary, the drug, alcohol, gambling, or other abuse problem, a beneficiary that's in a bad marriage or other relationship. The person has a lot of debts or unpaid taxes, they're in bankruptcy, or their special needs or disabled beneficiary, or they have a high risk profession such as law, medicine, accountancy, where they could be sued if they make a mistake. This type of planning can permit the inheritance to be passed on for one or more generations with the same asset protection, often free from federal estate tax in the future.
Here are the 3 levels of planning side by side.
So what's actually included in your trust plan? Well, you have the revocable living trust for probate avoidance, specially drafted if you have the enhanced plan or you've added the Castle Trust option. You also get the pour over will that pours assets into your trust at your death, any assets you may have left out of your trust during your lifetime. It's also where you may name guardians for your minor children. With the Castle Trust, you get that tube of toothpaste to keep your children's inheritance in the family. Now remember, we also said earlier it's not just about planning for death, it's also about planning for your incapacity. You get the power of attorney, durable power of attorney, so you pick someone to pay your bills, manage your accounts if you're incapacitated and cannot manage them yourself. This is customized with the enhanced trust plan option. You also get an advanced healthcare directive, customized if it's the enhanced trust option, or the statutory form if you have the basic plan. This is a document where you can pick someone to make healthcare decisions for you if you cannot communicate them yourself. You'll get a HIPAA authorization, which is a medical privacy form that gives your healthcare agents and anyone else you may have identified in the form the ability and permission to speak with your doctors to find out what's happening with you medically. There's a certification of trust, which is used when dealing with financial institutions or sales of real property, so that they know about your trust enough information that they need to actually work with whoever you have designated as your trustee. There's a general assignment of assets to the trust, which clarifies your intentions about what assets you intend to be owned by your trust today and in the future. And if you're married, there's a marital property agreement that clarifies whether the assets that you own are intended to be separate property or community property. That's also verified in schedules of assets attached to your trust itself. If you have minor children, a children's legacy plan with all the documentation previously discussed, transfer paperwork for one California real property, an estate planning binder, and electronic copies of your signed documents to make it easier for you to share copies with whomever you wish. My planning process is very straightforward. Because you've been educated by attending this webinar, it would start with a free preliminary planning session either by Zoom or in person in my office because you have decided to engage my services as an attorney to prepare your estate plan. At the preliminary planning session, we'll review your family circumstances and decide which of the 3 levels of trust planning is appropriate. I will quote a fixed fee for the level of trust planning chosen. You will sign an engagement letter in person or later in the day through DocuSign. You will pay me $1,000 to secure my planning services, and we will discuss the next steps in the planning process. I will then provide you with a secure online portal to share documents back and forth. I will put plan design worksheets into that folder for you to complete in the comfort of your own home. Once you've completed as much of those as possible, you will schedule a plan design meeting with me either by Zoom or in person using a link that I provided to you by email. Then when you're ready, the next step will be to schedule your plan design meeting with me.
So let's talk about the agenda for the plan design meeting. It's scheduled when you're ready to meet with me with your worksheets completed as much as possible. If you haven't already signed it, I'll have you sign the engagement letter at the meeting. You'll pay half of your fixed fee that is being charged, and I will design your estate plan at that time.
Once I have the complete estate plan design, I will draft the documents for your review and put them into the secure folder. Once the review is completed, I will have you schedule a signing appointment in person in my office where you will come in and sign all the legal documents I prepared for you. The documents will be notarized or witnessed as necessary. So if you're ready to move forward with your planning, your next step is to book your preliminary planning session. You can do that by going to the URL that appears on the screen, calendly.com/lawbob/attendee. You'll see my booking calendar, and you can pick a time for your meeting and whether you want to meet at my office or by Zoom. And if you have any questions at all about my process, plans, or fees, please feel free to call or email me. Here's my contact information. Go ahead and call or email me directly, and I'll be happy to help. Not everyone is a good fit for my firm, and since I have limited planning sessions available each month, I want to make sure they go to families who are serious about getting this important work done. These are people who should schedule the consultation. People who've taken the time to watch the webinar so they can make educated, informed decisions. People who do not have an estate plan or want to update their current plan, and people who are ready to get started with the process. I've found that preliminary planning sessions are not appropriate if you've interviewed or intend to interview other estate planning attorneys to just compare what they offer versus what I offer. If you're a do-it-yourselfer and are looking for ideas but you're not ready to move forward. If you already have a plan in place, unless you want to make changes. And finally, the preliminary planning session is not for people who want me to answer questions about their specific situation or circumstances, but haven't decided to hire me yet. And this is for liability purposes. As an attorney, it's not appropriate for me to give legal advice as it pertains to you and your specific situation unless you've engaged me as your attorney and signed an engagement letter outlining the scope of my legal services. While I can answer basic questions for you, as I've done in this webinar, I can't advise you on your specific situation unless you've hired me. If you do have some basic questions about my process, feel free to email me or call me, and the contact information is at the end of this webinar.
If you're on the fence about booking a preliminary planning session, I encourage you to read some of my client reviews on Google to learn some of the things my clients have said about working with me. I think you'll find my clients have great peace of mind once they've completed the process and have their estate plan in place.
Okay, so if you're ready to move forward with your planning, the next step is to book your preliminary planning session. You can do that by going to calendly.com/lawbob/attendee. You'll see my calendar, and you can pick a date and time for your meeting and whether you want to meet at my office or by Zoom. And if you have any questions at all about my process, plans, or fees, please feel free to email or call my office. Here's my contact information. I'll be happy to help.
Here are the 3 levels of planning side by side.